Greetings and good afternoon. I would like to welcome everyone to the public hearing for our Judge Chief Sellers. My name is Mark Baker. I'm the District 7 Councilman and Mayor Pro Tem for the City of South Fulton. I will be presiding over this hearing in the absence of our mayor, who has recused himself for his personal sentiments. And just FYI, professionalism is essential at all times, and we will move forward with this hearing with all due deference to the City of South Fulton and all due deference to our Judge, Tiffany Sellers. With that being said, Madam Clerk, please call the roll.
Good afternoon. Roll call for this afternoon. Councilmember Rao. Present. Councilmember Gumbs. Councilmember Willis. Present. Councilmember Gilliard. Rose Jackson. Councilmember Rose Jackson. Here. Councilmember Khalid. Mayor Pro Tem Baker.
Present.
You have a quorum.
Madam Clerk, please sound the first item.
The first item on the agenda is to remove the judge. Petition to remove judge. Public hearing.
I'll entertain a motion to approve the agenda.
I move to approve the agenda, petition to remove Judge Sellers, October 19, 2019. Second.
Any discussion? All of those in favor? Okay. Madam Attorney.
Mayor and Council, just to provide context, we are here today in response to the petition to remove the chief judge that was provided to the council, or that was introduced to the council by Councilmember Gumbs and was approved by the council on February the 26th of this year. And in that petition, there were, it set today's date for a public hearing to occur on the petition to remove. And for the council to have a public hearing that gives the judge a full opportunity to address the allegations that were made against her. It gives the public the opportunity to also address the council and give the council any concerns they may have for or against whatsoever with respect to the petition. Just for clarification, and pursuant to your authorization in earlier council meetings, I have provided the judge with the documents that supported the basis of the petition, and those are the documents that are in front of you. Those consist of the emails and correspondence that were provided to us by, and I'll say employee LC, using her initials, in addition to the documents and the emails and correspondence that were provided or referred to us by employee RH, who was the court clerk, and LC was the court administrator. Both employees have since resigned from the city. I don't know if they're present today. Do we have either of the employees present today at today's hearing? No, we did not require in any capacity. I do know that one reached out to me and she wanted to know if she was able to participate. I told her that we were not compelling or asking her to attend, but as a member of the public, if she wanted to attend, it was her choice. But we have not asked her to participate.
Right, do you have the letter on record that she said?
Yeah, everything that she gave to us, that she asked us to refer to, the emails that she asked us to refer to, are provided within the document, the packet that you have, and that document is also in possession of the judge. With the exception of, there is a video recording that was also provided to the judge that pertains to items 3 through 7 of the petition, but the video recording was also provided as part of the basis of what the council reviewed with respect to the petition to terminate.
One of the I don't know who her name, but she's one of the complainants sent an email today to the entire council and copied you.
Yeah, I have
She
not
sent a
reviewed
statement
that.
today.
Yeah, I have not reviewed her statement today, but because the judge has not been privy to whatever communication she made today, I would ask that you not include that email in the record. If she wants to come and speak as a member of the public, she's free to do that, as I've told her she could. But I have not reviewed the email, the correspondence that she might have just sent.
Okay, thank you.
So we're here today essentially just to move on the petition to remove. The general process that we're utilizing in this case is the state statute that sets forth, requires a public hearing on the removal. So the chief judge, we had a hearing last week and her attorney mentioned that she may have more to say to the council than 10 minutes would allow. So I've requested the time frame that she would like to speak, and I have not heard back. So if she has a preference on how long she would like to speak, I would give her the opportunity to make that recommendation so that you can vote on whether you'll allow her to speak that length. And if she has no preference, then I request that you give her up to 30 minutes.
Judge Sullivan, is that
I believe that appropriate notice that was provided to me via my counsel on February 28th indicated that I would have up to 10 minutes. Any additional time that was provided means that I've not provided adequate notice of that time. And so if there was any additional times or time frames changed when we were in court on last Thursday, you made it clear, Ms. Walker, that I would have up to 10 minutes. And that was actually double the state statute according to your statements to the court. And so the only notice that I've been provided was that up to 10 minutes. If the council wants to modify that, then that's the council's purview. And I have no opinion on that except to put my objection to the except to put my objection on the record to any changing of the rules on the day of the hearing. Thank you.
Well, my recommendation would be regardless, because her attorney did tell me that what she had to say likely would exceed 10 minutes. I would still say as a courtesy that the council still give her up to 30 minutes. And if she elects 10 minutes, then that's her discretion. But I would recommend that you still give her the opportunity of at least up to 30 minutes. And then I would also request that you give the public the same length. So if the motion would be, if the council allows, I move that we increase the time for the judge to respond to the petition to 30 minutes and allow the public to have equal time, which would be 15 minutes for, 15 minutes against, at the standard 2 minutes a person.
Councilwoman?
So just for clarification, we have the state statute, and the state statute does not define how much time we should give anyone for this public hearing. But you have organized this public hearing to follow in alignment with the other public hearings that we have, such as zoning. And so we do allow 10 minutes. There was several comments made in the media and per your statement that 10 minutes was not a lot of time to present the case. So we are willing to give more time on both sides, the public and to Judge Sellers. And so more time, more than 10 minutes. And so are you recommending that we allow at least up to 30 minutes on each side?
Yes, my recommendation is 30 minutes for the judge or any people who she has brought to speak that she would like to use her 30 minutes, but that she be given control of 30 minutes and that the public also equally get 30 minutes.
So I move that we allow 30 minutes to allow Judge Sellers to present. If she does not want to use 30 minutes, that's her, prerogative. She can use 10 minutes, but we will allow her up to 30 minutes, and we will also allow up to 30 minutes for the public to speak.
I second.
Probably move to second discussion. I have discussion, and I'm at liberty to have discussion even though I'm presiding correctly.
Yeah, you may have discussions on your
I have
part.
discussion in regards to that motion only because our judge has actually confirmed that she hasn't had enough time had she known that she had 30 minutes, she would probably prepare. I believe we should probably go forward with 10 minutes as we had offered, and she's already prepared to discuss for. And only at her discretion, personally, now, should we extend that time.
Do I have permission to speak?
But yes, yes.
I mean, if she wants to use 10 minutes, it's up to her. Where we're saying that she has up to 30 minutes. If she goes over 10 minutes, if she wants to remain at 10 minutes, that's up to her. But we are allowing up to 30 minutes. She doesn't have to use 30 minutes.
Okay, so for clarity,
Yeah,
if
she's
this
not
motion,
required
right, I'm
to speak
clear,
30 minutes.
but just for clarity, this body is willing to allow her to go past the 10 minutes? And it's, no, excuse me. For clarity, this body is willing to allow her to go past the 10 minutes that she's allotted at her discretion. And we'll move forward. With that being said, we'll also allow that 15 minutes,
Mr. Pro
yea
Tem,
or nay.
that was my motion.
I understand, but I just wanted to be clear. That's why I said for clarity.
Yeah, my motion was to allow up to 30 minutes. It's the judge's prerogative if she wants to only use 10 minutes, but we will allow up to 30 minutes. And we will also allow up to 30 minutes for the public. That was my motion. And it was seconded by Councilmember Jackson.
Okay, there's a motion on the floor. We'll take a vote. All those in favor? With that being said, Judge Sellers, you have the floor.
Well, actually, Mayor Pro Tem, if you could kind of give this clarification to the public on what they would need to do, what process as far as lining up.
Well, we're gonna allow Judge Sellers her 10 minutes further if at her discretion, and after which we will allow 2 minutes per member of the public in favor, 2 minutes per member of the public in opposition. And I believe our clerk may have received cards. And in this hearing for the public, in favor or not, we expect the same decorum in any public hearing in the council meeting. You clear? 15 minutes on each side, not to exceed 30 minutes.
Right.
Sorry.
Thank you. Before I begin my remarks, at the advice of my counsel, I'd like to place a few objections on the record to preserve them for the appeal of this matter. First, I object to my suspension, allegedly pursuant to OCGA 36-32-2.1, as there was no motion made to suspend me and no vote taken to suspend me during the February 20th meeting. Second, I object to this hearing pursuant to OCGA 36-32-2.1, as the vote to hold this hearing taken during the February 20th, 2019 meeting was taken in an executive session and not in a public meeting as required by the statute as well as Georgia's Open Meetings Act. I also object to the up to 10-minute time limitation that was arbitrarily placed on my defense by the city attorney, as the time limitation does not comport to and comply with the traditional notions of due process as required by the United States Constitution, the Georgia Constitution, OCGA 36-32-2.1, and the centuries of case law on the issue, and that the arbitrary time limitation does not allow me to call witnesses in my defense, present evidence in my defense, and does not allow for me an opportunity to confront my accusers. Finally, I object to the use or review of any documents presented to the council today. As Ms. Walker stated in open court on Thursday, that the city would not be introducing any evidence or documents at this hearing. Subject to and without waiving these objections, good afternoon. My name is Tiffany Carter Sellers, And not only am I a resident of District 2 in the city of South Fulton, I am the chief judge of the city of South Fulton's municipal court. I have served in the capacity as chief judge since September 2017 and was initially tasked with establishing the municipal court for the 8th largest city in Georgia in 40 days. Not only did I accomplish this very lofty goal within the time constraints, the court has also developed innovative programs aimed at the overall improvement of our city. Under my leadership, we developed the Green Team, our court's community service program, which allows offenders who have harmed our community by committing offenses in our city to clean up our city's parks and public roadways. We have also developed a robust pretrial diversion program, Second Chance South Fulton, which allows first-time offenders an opportunity to complete a series of classes and community service opportunities that not only restore and repair the offender's relationship with the community, but also provides them skills to enhance their lives. I'm proud to announce that all of the offenders who have completed our pretrial diversion, that out of all of the offenders that have completed our pretrial diversion program, we have a 0% recidivism rate. That is, we have not had a single person reoffend that has successfully completed our program. Additionally, under my leadership, every defendant arrested in South Fulton is provided the assistance of a public defender during their first appearance hearing in our city, a right not required by the Constitution, but one that should be. Finally, and I guess the real reason why we are here today, during my tenure, our court has risen to national prominence, bringing significant positive attention to our beloved community. Turning our attention to the allegations set forth against me, I have reviewed the petition signed by District 2 Councilwoman Carmelita Gumbs and served on my attorney on February 28, 2019. It is important to note, the petition does not allege that I violated any statute, federal or state, any law, any rule, or any judicial canon of ethics. The petition is simply a listing of inadmissible hearsay statements aimed at creating a false narrative to attack my character and undermine my leadership. The allegations contained within the petition fall into 3 categories: the alleged reality television show, the grievances of a disgruntled former employee, and the findings of an external audit of our department. Let me say at the outset, I unequivocally and categorically deny any and all allegations of wrongdoing in this matter. And while the 10-minute time limitation placed on my defense does not afford me a full and fair opportunity to present evidence supporting my denial of each paragraph of the petition, I will do my best to speak briefly to each of the broad categories. First, with regard to the television show, there was no reality television show filmed in our court. I never signed a network deal to create a reality television show in our court. There was never any filming associated with the reality television show of our court. No city employees or city resources were ever used to develop, fund, or create a reality television show in our court. As I have explained to this council previously, after the photograph of the ladies in South Fulton's criminal justice system went viral, we were contacted by nearly 20 to 30 television producers from around the world for a wide variety of opportunities, from scripted television series to docuseries to full-length documentaries. The 3 independent contractors in our court, Ms. Jones, Ms. Powell, and I, met to determine whether we were interested in pursuing any of these opportunities. And after we determined that we were interested, we contacted our city attorney, Ms. Amelia Walker, to inquire whether we needed to seek approval from this council to proceed with the show. On October 15, 2018, at 6:42 p.m., Ms. Walker replied via email that we did not need to seek the approval of the city council if the show was not going to use city resources or city employees outside of the scope of their employment. If I had the time, I'd circulate the email for your review. She did or call Ms. Walker as a witness. She did suggest that we notify the city council, and based on her recommendation, Ms. Catherine Vaughn, president of good paper content, came to the November 13th, 2018 work session of this council and presented her idea for a show featuring the court. Shortly thereafter, Ms. Jones, Ms. Powell, and I each individually entered into an exclusivity agreement to pursue the development of an idea for a show featuring our court with her company as opposed to the other 20 to 30 companies that had contacted us. We had no idea the council was against the show. And when we learned that the council did not want the court to pursue the show, Ms. Jones, Ms. Powell, and I met and agreed to terminate the idea of pursuing the show. With regard to the accusations of a disgruntled former employee, let me be clear. I am not a bully, and any claims to the contrary are slanderous and false. Quite frankly, if we really want to get to the truth of the matter, a full and fair evidentiary hearing is absolutely required and mandated by the law. Since the court's inception, we have processed well over 6,000 citations, and we see an average of 200 people in court each week. I have had the privilege of working with more than 15 of our city's finest police officers and several of the best court professionals in the business. If you really want to know if I'm a bully, let's have a hearing where we can ask them. Bring these individuals into the court and ask them about working with me. Ask them whether I'm rude and disrespectful. If you really want to know about my judicial temperance, ask one of the thousands of defendants who appear before me whether I'm rude, disrespectful, or a bully. If you really want to get to the truth, why haven't we asked the city's Human Resources Department about the complaints and grievances filed against that disgruntled employee by subordinate members of her staff? Why don't we review her 90-day review where she was placed on an extended probation by the court administrator? Why don't we ask to see written discipline she's received as a result of her terrible attitude and behavior? I welcome a full hearing on this issue and on my decisions to manage a difficult employee, because I am confident that at the conclusion of that hearing, you will determine that my actions were completely justified. After all, the city attorney, Ms. Amelia Walker, opined via email on October 4th, 2018 at 7:38 p.m. that I had the authority to preside over the court and ensure the orderly and legal operations of our city's municipal court. Again, if we had a full and fair hearing, I'd present not only that email, but also offer Ms. Walker's testimony. Finally, I understand that some of the members of council are concerned because of the findings of an external investigation and audit in our court. I have reviewed this document and I have a copy of it here today. Let me say that in any new city, external audits into the administration of a department should be a welcomed, positive activity. These investigations and audits provide much needed feedback to help the organization excel, or as Mr. Donald says, be world-class everything. It is important to note that there were several departments on which an internal investigation was conducted. The investigation into the court never once called for the suspension or termination of the chief judge, and any suggestion to the contrary is blatantly false. The recommendations did not even include the recommendation for the discipline of the chief judge. The recommendations were simply that, recommendations to improve overall court operations. I stand here proud to announce that all 5 of the recommendations were immediately implemented, and there are no outstanding items to be completed. Again, if you don't believe me, I welcome a full and fair hearing where I have the opportunity to present evidence to support my position. In sum, I have faithfully and dutifully fulfilled my role and executed my responsibilities as Chief Judge of this city's municipal court in a manner that I believe would make our residents proud. I have done nothing wrong, and I welcome an opportunity for a full and fair evidentiary hearing on these allegations. After all, can we imagine a world where governments were simply able to make accusations against individuals who were not able to call witnesses or present evidence in their own defense, but were simply given 10 minutes to plead their case before a decision was rendered? It is my hope that in the progressive city of South Fulton, we aren't the leaders of that trend. Thank you for your time and attention to this matter. I reserve my remaining time for rebuttal.
Madam Clerk, do you have the names of those individuals who are speaking
Yes, sir.
against?
The first one, we have a
Against.
total of 14.
So these are speaking against?
Doesn't say whether they're
Okay.
against or not.
Out of those 14, we need to have those who are coming forward and filled out a card against to approach the podium, please.
Explain against the petition.
That are for the removal, I'm sorry.
Oh, another removal.
Okay. So are there any, there's no one who filled out a card that stand against the removal of Judge Sellers? So, who do you want to hear? I want to hear first those who are for the removal of this, of Judge Sellers. Okay, so those individuals, you can call their names, and you each have 2 minutes.
The first lineup in this order: Gary Kemp, Leslie Kimbrough, Teresa Carter, Reginald Tatum, Brandy Fulton. I call 5 at a time.
I'd like to waive my time because my question is and concern are one of general leadership recruiting of the city. So I think this is better presented to the full council at a regular meeting.
Good afternoon. My name is Leslie Kimbrough, and I'm from the city of Atlanta. And I am a dear friend of Judge Sellers and her family. We have worked together for about 10 years at a law firm, and I know her character. She's a woman of God. She worked tirelessly to develop and put the judicial system together for the city of the municipal court. We prayed, we talked, sun up to sun down. And I'm just appalled that we are here today. And so my prayer is that you will look at her heart and you will look at her character.
Thank you. You come forward, please state your name and your district.
My name is Teresa Carter. I'm from District 4. And Judge Tiffany Carter Sellers is my daughter. She is a woman of integrity. And for her to be here today is a travesty. You have never heard her speak negatively about this city. She's been interviewed. When I look around, I see Councilman Baker. She came to your workshop with your boys on a Saturday. She didn't have to do that. Councilman Khalid came to your town hall to speak. She didn't have to do that. Councilwoman Gilliard, she worked for you before she even got to this position, and yet you would hang her character. Councilwoman Roel, you brought kids to her courtroom because I saw them. She took time from her lunch to show those kids that courtroom. I am appalled that you all would sit here and judge her character over hearsay, that you would destroy her reputation over hearsay. He said, she said. That's what it's all about. Think about what you're doing. This city has always been lifted to a higher standard because of her and because of the things we can do. I am proud to be a citizen and a resident here in the city of South Fulton, and I absolutely love my district. But what I see here today makes me ashamed. Thank you.
Thank you.
Good afternoon, Council. My name is Reginald Tatum, and I live in District 1, and I'm a citizen of Southwood. I'm not here by no means to try to undermine you all to see what you're going to try to do. But I had the opportunity to sit in Judge Sellers' courtroom, and that was one of the most effective ran operations that I've seen. And when I reflect back on my young childhood, I was in school, in high school, and I got a traffic violation. And I had to go downtown on 20th Avenue. And if it had not been for my uncle to come down there with $35, they would have arrested me and put me in jail. But when I went to Judge Sellers' courtroom, I saw a different side of this. But let me tell y'all something, council members. You know, let's knock trauma from the inside. We can't do that. This more than about just removing a judge. We talking about the city of South Fulton's image. And whatever our problems are, especially with our young people, we got to put some kind of mechanism in place to say, look, you might be just a little off course, but here's what you need to do to get back on course. If they don't do that, then severe action should be taken. You follow me? Because our image plays a role in economic development and everything else. And especially when you got a court system that went viral all over the world. I thought that was something that we could build upon, not try to tear down. Let's build upon it. And we got to do one thing. We got to help each other. There's no question about that. And I ask you all in y'all decision, let's reconsider what we're doing. Thank you. Thank you.
Hey, I'm Renew. I'm in District 2. I was in Judge Sellers' courtroom.
State your name, please.
Renew. Brandon Fulton.
Thank you.
I prefer Renew. I don't know Tiffany. All I know is that she upholds the law. The true bullies in the town is Bill and LaDon. That's who the bullies are. They're wasting taxpayers' dollars, and they try to put me in jail. And this woman right here made them follow the law. They put a motion of contempt to lock me up. And this woman said, there's no motion of contempt because he never came in court about the situation. So I don't know, but all I know is that he came out the back room, and he's supposed to be sitting in the public because he's not officer of the court. And I feel like I watched them pressure her and LaDon to make them lock me up, and she didn't. So I'm just saying, we not cool, we not friends, but she follows the law. That's what I'm saying. Taxpayers is wasting money with that dirt on button the road, and it's just crazy that they pushing the agenda and making this woman look bad because she's not doing what he wants or what LaDon wants. And this is just something personally. This me and Bill talking. He said the place. Oh. I can email y'all the video. Everything starts from the bottom. He's a fraternity man, an alpha. Martin Luther King said, I had a dream. He said he started from the top. He don't know what it is to be at the bottom. So I think he's the real bully in LaDon Jones. And I can email it to everybody in the city of South Fulton.
Next slide, Joyce Armster, Nancy Sargent, Demetia Chapman, Walter Kimbrough, and Donnie Prairie.
Good afternoon, my name is Joyce Armster and I'm from District 6. It is apparent that the accusers in this case has no regards for authority or leadership. Otherwise, they would not have thrown rocks and hid their hands. I recommend that Judge Sellers remain in her position and continue to carry out the laws of the land and hold her staff accountable for all duties assigned. Members of the council, I don't know if you are aware of the laws of reaping and sowing. Be careful how you uncover the faults of others because you just might expose your own criminal tendencies.
Good afternoon. My name is Nancy Sargent. I reside in District 6. I'm here to speak on behalf of Judge Sellers. I know her to have a sweet, sweet spirit, and I can't say that about very many people. I've only seen her in public occasions, public meetings, and she has conducted herself in a professional way. I'm not happy with these charges that you all have come up with. I'm not happy that you gave very little notice of this meeting and have it at a time where no one other than us folks that don't work can attend. I know you probably came here with your minds made up how you're going to vote, but two wrongs don't make a right. And there is no right way to do wrong. Thank you.
Thank you.
Thank you. My name is Demetra Chapman. Thank you, Mayor Pro Tem, Council. I'm not here to try to persuade you, but only thing I ask you guys to do, and my council lady, thank you, Council Thumbs, is to give her a fair trial. When have we started handling HR problems out in the open? Because I'm finna step on some toes now. If y'all, I didn't see Council Jackson when she was allegedly supposed to have been tasered and it was all on the national news. Y'all put it before the public. But it was out there. And then let me say, Council Lady Jackson, yes, I got a text and it was cleared. And when I saw it, I said, thank you, Jesus. What I was taught and raised, my grandmother used to always tell me, be careful of the bridge that you cross, because you got to come back over. Be careful how you treat folks, because them same folks you mistreat going to have to give you a glass of water. I'm not here to try to judge none of you guys. You were elected to do the right thing, and I've always said, and I've had more talks with Council Lady Willis and Raul, I always say, and I love them, get self out of the way and do the right thing. It's not about none of you guys. It's about doing the right thing. Council Lady Jackson, when I saw how your name was all over the news, and I had a relative say, what the hell is going on down there in that city? I didn't say anything, Council Jackson, but I prayed. And I said, whatever come out that case, let the truth come out. When the truth come out, if it happened or not, all I know what was said on the AJC. I felt for you because it was your character. I felt for Helen Willis because it was her character. Judge Sellers, it's your character. I had a young man living in Walden Park said, when I met with her, she was an awesome judge. And I promised her that I would not stand before her again. I want you guys to do the right thing. Thank you.
Thank you.
Good afternoon. My name is Walter Kimbrough. I live at 824 Dolly Avenue in District 1. And I happen to be the pastor of the Cliftondale United Methodist Church on Stonewall Road. And I'm serving again as pastor because I have successfully flunked retirement multiple times. I've come this afternoon because I happened to be present when Judge Sellers took the oath of office. And I was extremely proud to be present and honored to have her as our judge, my judge. And I've come this afternoon because there is a recommendation to remove her. And I could not be satisfied by staying away. The story is told of a woman who had charges brought against her. The people, the leaders of her community, had charged her with a serious crime. And the law had said such a person who had been caught in adultery should be stoned to death. And there was another person who came along and simply said, all well and good. These persons, these men had rocks in their hand, ready to stone this poor woman to death. And this one person said, let the one who is without sin be the first to cast a stone. And as the story goes, that this person stooped down on the ground and began to write. And the question is raised, what did he write? He wrote their names. And after that, he looked up and they were all gone. I pray that you do the right thing. God bless.
Thank you.
Good afternoon. My name is Donnie Perry, and I live in District 2. And it's never an enviable position to come behind any pastor, especially renowned pastor like Pastor Kimbrough. But I will say this. I think that Councilman Goff is a woman of integrity. I also think that Judge Sellers is a woman of integrity. There's something here, and the truth probably lies in the middle somewhere. I can tell you that there's something there. I just can't believe that Councilman Gomes and the other council members would put their name to a document and go under public scrutiny for no reason at all. It just doesn't make sense. And being a big watcher of Judge Judy, she says it all the time. If it doesn't make sense, it's not true. It's truth there someplace. Now, I will say that about the image in the picture going viral. And it did cause me some concern, but I was concerned for the wrong reason. I don't ever want to go to a courtroom where there's nothing but women. I want to see people that look like me, because most people coming up there will look like me. So what I want to leave you with this, council members, I don't know what Judge Sellers' future may be, but I will say this, when considering appointments, always consider the diversity of the community. What it's going to look like, the optics of that picture. That's a very important thing as well to consider as we go forward, and being the city that can be that shining light on the hill for all the other cities in Georgia to see. And I thank you for your service.
Thank you.
Our last set is Barbara McGee, Harold Reed, Shanika Musgrove, Veronica Richardson, and Alvin Reynolds.
Good afternoon. My name is Barbara McKee, and I reside in District 6, Councilman Khalid. And I'm here this evening. I probably need to preach a sermon, and I can't do it in 2 minutes.
All right.
First of all, I want to hold my councilman accountable. As I spoke with you some time before, I said I will hold you accountable when I was praying with you. I'm sure you remember, sitting in my living room. And I'm holding you accountable this evening. I don't know Judge Sellers, but I do know, except the Lord build the house, we labor in vain. And I don't want to live in a city that's on the news for this. I want to live in a city where there's a youth building has been built. There's data where our children is not running all around South Fulton, Fairburn, or robbing an IHOP. Again, I say, except the Lord build the city. So we can sit here, we can judge whomever, but God is really the ultimate judge. And I did hear one say that there's some truth in the middle. It might be on the side, it might be in the top, it might be on the floor. But this is not a city that I want to live in and see on the news. Today I had the opportunity to just see children being put out with DFAC. Families don't want them. Surely there is more to do in this city. And I'm holding everyone accountable up here that we need to look after our children, look after our elders. There is so much more that we can be doing. I don't have the answer, but God does. And again, except the Lord build the city, we all labor in vain.
Thank you.
Good afternoon, council. My name is Harold Reed. I reside in District 2. I am one of those retired folks But during my roughly 45-year professional career, I managed to rise to B-band level within a major corporation here in the United States. I cannot say every one of my subordinates agree with everything that I decided to do. I also cannot say that I wasn't challenged by some of those decisions, by some of those employees. But I can say, when it was brought before Human Resources, I never lost one of those decisions. This is a human resources problem that has been elevated to the point of fodder for those people who said we can't make it. Now, it never should have gotten this far. And I have tried to sit back and look at all of the things that have been presented. I've read and reread and reread every petition that has been put out for public consumption. This never should have come to this point. Now, you can make it right, or you can continue down this folly, but we will remember.
That's right.
Thank you.
I'm Dr. Shanika Mulsrow, and I'm in District 3, and there's Willis, I think. So when I learned about this, I think it's on your Facebook page. It's a sad time, but when I looked at the petition, so at this point I started looking at the petition, started reading the AJC, CNN, all these different things, trying to put the story together. And it's just, in my 20 years of working, it's confusing that Tiffany, Judge Sellers would sign a contract on July 18th, and then reading through these accusations, I think the first one starts on July 10th, and I've just never seen where HR would allow someone to re-sign a contract with these type of allegations, investigations going on. The other part that's disturbing is the allegation started with, I read in, I think it's the AJC that said that once they discovered that there was a reality TV show, it opened up the investigations. Again, as I read through the petition, I keep seeing two people. It started off with a disagreement with the clerk. You see that through 3 pages of documentation, I keep seeing the same name, same story with the clerk. As a professional, I have people, if I have a disagreement with someone, you can have, in 60 days, you can have over 100 bullets because there's gonna be tit for tat. So it's just confusing that you're able to terminate someone off of a disagreement with one person. And then another individual not agreeing with that, so now you have 2. And they've since, in Georgia's right to hire, right to fire, you're saying you work at will. They resigned, they moved on, and they're not here to speak for themselves. It's also confusing. I read words like she's a habitual interference, whatever that is, but basically continuously unable to control herself. Within 10 days of signing a contract, now you can't control yourself. And then you said that she's a disrepute, which means that she's ashamed to the company. She hasn't shamed me in any way. And then there's another word that she's prejudicial, which means that she's detrimental or harmful to the administration of the courts. I haven't heard that.
Thank you.
Good afternoon. My name is Veronica Richardson. I know Judge Sellers from college, law school. She was my colleague before she became my friend. I have known her for quite some time. Oh, and by the way, I'm counsel in District 2. Is that okay? Okay. Veronica Richardson. Okay. So with that being said, number one, I want to speak to her character. I have never known Tiffany to be a bully in any shape, form, or fashion. I have always known her to be someone of just character and someone who wants to do a great job in everything that she does. I did look at the petition and imagine my surprise when I came here today and learned several different things from Judge Sellers' opening statement that was not necessarily included in the petition. So it appears as if there is a lot of misinformation, and my issue is, as several have already stated, it should have never come to this point. What actions were taken prior to it becoming a public hearing? So my last statement is that it appears that the council, in doing it this way, are actually doing the same things that you're actually accusing her of in bullying. And I think that should be corrected.
Thank you.
Good afternoon, Council. My name is Alvin Reynolds, and I reside in District 7. I am here to speak on policy. I am a director in corporate America. I am a small business owner, which means that I have employees. And in both settings, there's this thing called HR. Now, when Judge Sellers came before you in her opening statement, she made something that I had to get up and speak on. And that was that there was not due process done from an HR perspective. I wanted to know, and I wanted to hear more because I don't have all the information and so forth, but what I read, I don't know if that process took place, that things went through HR. You know, when there is a complaint brought from an employee, oftentimes it goes through an HR process. Now, I sit here and I heard a lot of statements and everything, but when she stated that that process did not take place, I was a little perplexed. And I just want more clarity on that and make sure that this city, council, mayor, are following these procedures. I'm a policy guy, and I'm gonna tell you, a lot of this information seems to be omitted from the public, but that right there stands dear to me, that if policy is not being followed, then we have a problem. And I really hope that it is. I really hope that it is, because these are serious allegations to one of the highest positions in this city. Thank you for your time.
Thank you.
Therefore, Chairman Council, that ends public comments for this session.
I know that was all of the people with cards. Did anyone come in late? Do we have enough time? Are we going past the time? Excuse me. Okay, with that being said, I believe Judge Sellers has approximately 18 minutes and 54 seconds if she would like to continue.
Quite honestly, I don't, the only thing that I have to say is, if there really are issues, if there really are concerns, why not a fair hearing? Every day people come into my courtroom charged with a wide variety of charges, from parking citations, grass cutting, shoplifting, whatever. And guess what they're all provided? An opportunity for due process, a full and fair hearing, an opportunity to present witnesses, an opportunity to cross-examine witnesses and confront their accusers. Why am I not afforded that same opportunity? That's it. Thank you.
At this point, we close the public hearing. And there are a couple things that I would like to give our attorney an opportunity to expound upon. When we leave your presence in these meetings, we oftentimes go to executive session for personnel, real estate, and litigation, because there's certain things that we can't spew publicly. With that being said, there's a process, a formal process that I heard come back, and it was reoccurring, a theme through our public, and I would like for our attorney to expound on the process for a petition to remove the judge in the city.
So I guess so in responding to some of the comments, I think you would like me to respond to some of the concerns that were raised by the public. Is that what you would like?
Yes.
So I heard a concern being made as to maybe a vote or a motion by the council in private. I will say that as an officer of the court, the council in this case, at no point in my presence voted in any capacity on anything public, on anything involving this matter in private. There has been zero vote by the mayor and council in private to terminate the petition, to move forward with the petition. There was a vote, a public vote on February 20th. On that date, The council voted publicly. There were people who were in the meeting area. There were members of the public who were there when the council voted. They did not vote in executive session. We had executive session in the mayor's chamber. There was 0 vote in the mayor's chamber to do anything with respect to anything. But when we came back out for public session, there was a vote. And the council set the hearing in this matter 10 days from the date that they decided to move forward. And actually a little bit more because there were weekend give or take, but they set it for March the 5th. There is a state statute that requires that this process be public. I know there were comments that were made about why this is an HR matter. It's an employee supervisor situation. Why are you handling it publicly? Well, for clarification, the judge is not an employee. She's a contractor. That means that if she works 1 day, she gets paid for the entire month. If she works 1 hour, she gets paid for the entire month. So she is a contractor. Her contract makes her a contractor. But even above and beyond that, the state statute that we are operating under specifically states public hearing. So it requires the mayor and council to do this publicly and to involve you and to make sure that you are aware of what's going on versus having something be done, you know, kind of behind the scenes and pulling in people and having it done at City Hall. So that's the reason why we are here and you're here and you know everything that's going on.
There are a few other things that I would like to clear up as well. And thank you everyone that has come out and to participate in this public hearing. First of all, the council didn't bring any action against this judge. We didn't know anything was going on. We didn't know there were any personnel matters. I left to go out on sick leave in December. I got back in January, and this internal investigation fell in my lap. I was under the impression, like everyone in this room, that this court was being run professionally and efficiently. So to find out not 1, but 2 on the record employees complained about being placed in hostile work environments and then also being bullied, for me, I can't tolerate that. We get on children for bullying children. So we can't tolerate that in a work environment. I'm an advocate for fair employment. I worked for the Department of Labor for 5 years, so I do understand employment laws. So the fact of the matter is, we had 2 employees who complained on the record. There were several other employees who complained off the record. But we cannot talk about off the record complaints. We can only talk about on the record complaints. I voted for Judge Sellers. Many of you all can go back and watch the tape. She barely got the judgeship. I was one of the ones who advocated for it. Go back and watch the tape. So I'm very hurt that we are here in this place. But we cannot tolerate employees feeling bullied or being placed in hostile work environments. We did get information from HR. We got all the emails, we got all the complaints. So we're not only working with an internal investigation, we had IT go back and pull emails. So we do have a little bit more information that we can't be forthcoming with because we don't know where this is going to go. So I do want you all to remember this day and remember all of us for doing the right thing. Lastly, I'm going to say this. I am one of the ones on this council who does take training, who does go outside of South Fulton. I just got back from DC, who does talk to other cities, who does do their research, who does ask how other cities run in their court. And I cannot find one court in over 500 cities in the city of Georgia and over 1,000 cities throughout the nation who allows any type of taping in their courtroom. Most of the cities that I have talked to, their focus is running an efficient and professional courtroom. That's it, not a reality TV show.
Councilwoman Jackson.
I would just like to ask our city attorney to play the tape that she has.
I'm going to object to that on the record. At the end of the day, your city attorney opined in court on Thursday.
1 second.
I'm sorry, I just have to put my objection on the record.
Yeah, you're out of order right now. I want to allow her to finish, and then if there's something that we can move forward with, this is not like public comment section is closed. If it's not something that we should do, Madam City Attorney, you advise and we go from there.
Well, as far as playing a record, I would limit it to what has been provided to the judge. If you have questions, because I know that the only record I'm aware, and when I say record, I mean an audio recording. Is that what you're referring to?
Right. That you share.
So the only audio that I'm aware that formed the basis of this termination is the audio that references items 3 through 7 of the petition to remove. That is the audio where the court clerk provided notice to the council of what's stated in the petition. If you have the petition before you, it's the court, she provided notice that she was being bullied by the judge and that every time she told on a certain person who was subordinate to her, the judge retaliated. So she referred us to a portion of the court transcript, the recording of court that day, where she says that you can hear the judge on that recording, you can hear the employee. She sent the employee an email saying, please do X, Y, Z, we need this task accomplished. The employee thereafter, and actually versus me summarizing, probably if you'd like to hear the tape, we've provided that to the judge, and then you can, it probably would be better for you to ask her questions as to the circumstances versus me, because I don't have direct knowledge, I wasn't present, but we can play the recording, and then if you have questions to the judge, you can, I think it would be appropriate to ask her that.
With that being said, is that something that's lawfully admissible?
Yes, you can play the recording to ask questions because this has been provided. We are not introducing anything into evidence here. What we are doing is that we are documenting this proceeding. So that means that anything that we review during the proceeding, anything that the judge provides to us, anything that the public provides to us, the comment cards, should be memorialized and preserved so that on appeal, the court will have full access to whatever was reviewed or was provided as the basis for termination. That video recording is a public document. You are allowed to play it if you wish to ask the judge questions on it and to see if she'll respond back. It's your discretion.
Well, actually, at your discretion, legally, I'll allow you to opine on whether or not this is something that we should do.
Legally, because it is a public document, if you want to play the recording, there is nothing that is legally prohibiting you from doing that.
You're out of order.
I'm sorry, but this is a legal
But
proceeding.
you are out of order, and we allow you.
I need to place the
Judge
objection
Sellers,
on the
I need
record,
you to have a
okay?
seat.
I need to place the objection on the record to hearsay.
Thank you.
Yeah, the recording is of Judge Sellers. So we're waiting for. Oh, you're waiting. Will you play the recording, please? If you'll give the clerk a couple of seconds, maybe a minute to hold the recording.
For Thursday, October 22nd. All right. Ms. Jackson, Ms. Powell, who are we taking first? It looks like there's a couple of names, is that correct?
Do we need to go to executive session?
I want to have that be for the shower, for the defender to speak. Give me a moment, sir. I do think give me your record. I'm going to require that you post a bond. I'm going to require that you post a $2,000 straight bond, which means that you can pay 10 to 12% of that to secure your release. Once you're released, you'll be returned to College Park, where, as you said, they'll throw the case out. Throw your College Park case out.
So it's a comment that was made by the judge that's about to start within the next 15 to 30 seconds. But it might be a whisper, so I don't know if you'll be able to hear it in this forum.
Do you want to tell us what this recording is?
This is the recording for items 3 through 7 on the petition. And actually, it's so low, you can't really hear the whispering. What I would recommend is that it is a public document. If people of the public have questions about it, you've authorized us to disclose this to the public. They can submit an open records request and get a copy. Because it's so low that you can't hear her, and I don't think, unless I bring the judge literally right here, I don't think she'd be able to hear what she's saying. Well, it's a statement that was made by the judge, so she would have the opportunity to state, or I think you should, if you listen to this, I think you should give her the opportunity to clarify what she said.
Right.
The problem is that it's so low, without me literally bringing her right here, you're not going to be able to hear it.
Okay, Councilwoman Jackson, Councilman Khalid.
As you can see, this is a very unpleasant set of circumstances that we find ourselves in. I heard amongst the public comments, calls, and Judge Sellers' testimony, I heard calls for more transparency, for a full hearing, and then I heard calls to not be in this room at all. So there are people who want us to be more public. There are people that want us to be less public. We are governed by a certain set of rules by the state code of Georgia and by our own city charter. But to err on the side of decency, I make a motion now that we go to executive session.
Second.
Probably moved to second.
And I would like to, if you could clarify that it's for personnel to discuss this matter, because it
Actually,
is a
only
special meeting. You're limited.
deliberation, because we can't discuss anything other than this item during this meeting. Probably moved to second. All those in favor?
Discussion, can we limit, just because we have people here waiting, and so can we limit executive session to no more than 10 minutes?
You may place a limit, you may place a limitation on your executive session, that's correct.
So can we limit, can we discuss whatever we want to be able to discuss in 10 minutes or less?
That's Councilman Khalid's motion.
Can we discuss whatever we're going to discuss? Will you, can we vote that we discuss whatever we need to discuss in 10 minutes or less?
Councilmember Khalid's motion is on the floor, so unless he amends it, you would then need to vote on his motion and then vote subsequent to that if it does not include your request.
We have been historically bad with time. It is my hope that we will begin our work session. Thank you for all of those who have come out.
Any more discussion? All of those in favor?
Luddites, why are y'all against using our technology? If we use a machine learning,
Right, Corey.
we need to. If everybody has a laptop.
I move.
I entertain a motion to reconvene the public hearing.
I move that we reconvene public hearing.
Did you close executive session?
No, we just got
Oh, you already
direction
did
from the
that?
clerk. I move that we reconvene public hearing Tuesday, March 29, 2019. No, she said we did not have to do that.
Yes, second. Second. All those in favor? Any discussion? All those in favor? All right. Madam. Council.
Attorney Walker,
Council, can
we
you
got,
please opine
Yeah.
on
we got
the ending
instructions.
of reconvening the public hearing or adjourning the executive session?
My request would be, so I've heard from the clerk, but my request would be not to start that practice today. Out of caution, if you could just out of caution close executive session.
Clear, thank you. I entertain a motion to close executive session.
I make a motion to close executive session.
Second.
Second, any discussion? All those in favor?
So
We're
we're
clear.
gonna reconvene now?
So
And then now you can close the,
I'd like to make I'll entertain a motion to
well, you can
reconvene
close
the
the public
public.
hearing as the presiding officer. You can close the public hearing.
Madam Clerk, we're not gonna close the public hearing because we haven't had a motion, correct?
Correct, so you can close the public hearing and entertain motions. Yeah, so you can say,
I've already closed the public.
oh, you've already closed it, okay, so you can entertain motions at this point.
Okay. I'd like to entertain a motion.
Pursuant to OCGA 36-32-2.1, governing the process for removal of municipal judges, I move that we remove Tiffany Sellers from office as Chief Judge for the City of South Fulton, effective today.
Second.
Probably moving second, any discussion? All those in favor? All those opposed? 6 yeas, and that. I'll entertain a motion to adjourn.
I'd like to make a motion that we adjourn.
Second.
Probably moving second, any discussion? All those in favor?